Hi, my name is Goldman. I'm an attorney from Goldman and Associates. Today I'd like to talk about a topic that has been brought to our attention by many of our clients, and that is the impact of COVID-19 on parenting time. Parenting time specifically incident to a divorce. As you may know, during the divorce process, while the courts and the attorneys are trying to figure out what's going on and where we're going to be, while they try to roadmap the future as it relates to kids, there's parenting time. The court establishes interim parenting time in most circumstances so that we can begin the process of seamlessly transitioning the children to this new situation where they essentially have two households. But what do we do in a COVID-19 situation, and how have the courts been reacting to that? Now, initially, the courts were taking a different approach. As soon as someone raised the issue of COVID-19, not knowing what it was, not knowing what to do about it, the courts were saying, okay, better safe than sorry. And they were separating and keeping the parenting time down to a minimum in the threat of exposure to COVID-19. At this stage of the game, 6 months into it, the court has heard it all. Okay, so if a parent wants to say, well, I didn't send my kid to a scheduled parenting time for fear that there might be exposure, the courts are not buying that. The courts are not going to allow themselves to be manipulated like that. Therefore, if you're in a situation where there's a genuine exposure, where, for example, someone in the household tested positive for COVID-19 and unbeknownst to you, your child was there, and now you're worried about possible cross-contamination and exposure, that's legitimate, and the court will certainly be sympathetic to taking appropriate action. What parents should do is they should work together to secure the environment, make sure that it's as healthy an environment as possible, and then file appropriate motions to get guidance from the court. However, what parents should not do is call up the other one and say, well, I'm not sending the kid for scheduled parenting time because I heard there was some exposure there. The court is not going to be very sympathetic. That's a quick way to be held in contempt. So don't do that. Obviously, you have to follow reasonable and appropriate protocols to safeguard your child, but at the same time, don't think for a minute that you'll be able to use this and somehow manipulate the situation in your favor, everything done under the auspices of a supposed COVID-19 threat. The courts are wise to it. The courts don't like it. If it's real, the courts will be there for you. If it's phony baloney, the courts are not going to support you. If you have any questions about this from either side, give us a call, and of course, we'll be glad to help you out.